Um, Greetings to everybody who is joining our live air. My name is Marta Pavlishina. I'm the expert of the Eurofem Education Center. So while you are connecting, I would like to explain why we have gathered today and who is going to be present with me. So today we are going to discuss the tool which is called universal jurisdiction. We are going to discuss how it works, what is meant under this word universal jurisdiction, what is the procedure of bringing people to responsibility, and what are the prospects of using the universal jurisdiction in terms of bringing people to responsibility for war crimes in the context of the Russian aggression against Ukraine. So today we are going to have our partners from the organization Clooney Foundation for Justice, Katerina Busol and Antonia David. In particular, Antonia David is a lawyer, an advocate, and a legal program manager of the Docket Clooney Foundation for Justice. So she was developing a very interesting tool that we are going to discuss today. This is the project called Justice Beyond Borders. This is a global tool which is using mapping of 216 jurisdictions, and this map can help you to find possibilities of investigation of mass atrocities committed abroad. Probably a lot of you already know Ms. Katarina Busol, because probably this time, previous year, we had a series of webinars with Ms. Katarina, where she was a speaker. She is a Ukrainian lawyer and a senior professor of the Kiev Mohyla Academy, and also a consultant of the Clooney Foundation for Justice. She used to work a lot on the topics of responsibility and interim justice. And today I would like to underline that if you have air raid alert in your settlement or town, please stay safe, go to the bomb shelter, and later we are going to share the recording on our Eurofem platforms that we have. So please stay safe, go to the bomb shelter if necessary. So I would like to give the floor to our colleagues.
Hello, everyone. Thank you very much, Marta, for that introduction, and thank you for everyone at Eurofem for inviting Katya and myself to speak today. It's an honor to be here, and thank you very much for taking the time to be here and to be interested in this topic. So as Marta said, my name is Antonia. I am a legal program manager with a Docket. I'm a lawyer, and I've been working on our Ukraine project since March of last year. So the Docket is part of the Clooney Foundation for Justice, and it's the part of the foundation that is specifically focused on seeking accountability and justice for victims of mass atrocities. And so we have a team that's largely international lawyers, analysts, and investigators working on cases involving international criminal law. And so Katya and I wanted to speak to you today about how accountability efforts abroad, so cases outside of Ukraine that are brought under the principle of universal jurisdiction, how they can fill an important accountability gap and even impunity gap for bringing justice for survivors, including survivors of conflict-related sexual violence. So before diving into the law, I wanted to start with an example of the kind of work we do and how we do it. So as part of the work we do, like I said, we have investigators on our team. And part of the work we do is to conduct field work along with our local partner organizations and other NGOs that we work with. And so we do this to sort of help support authorities in building criminal cases. And so in the situation of Ukraine, on one of these trips in October this past year, we had a team that was working outside of Kyiv, where, as all of you know, February and March of last year, Russian forces occupied towns in this region for a couple of weeks. So once our colleagues, along with our local partners, were in these villages, they began talking to people, and they started to find general patterns of what had happened to people there over the course of Russian forces essentially occupying these towns. And these will all be familiar to you. While they were occupying the towns, Russian forces were staying in houses, sometimes kicking people out. They were conducting house-to-house searches, detaining, sometimes torturing and executing people that they believed were helping Ukrainian military in some way, and they were looting. And then as our colleagues were speaking, they had the chance to speak with one woman who told them about the rape that she suffered from Russian forces while they were occupying their town. So she explained that on the first day, a group of Russian soldiers came to her house, questioned her and her husband. The group of soldiers included a man who sort of seemed to be in charge of the group, who was giving instructions to others. They came back the next day, took her husband away, and then sort of trapped her in the house and committed the rape. After a few more weeks of occupation, the area was liberated and Russian forces left. So why do I sort of start with this case and share this particular story? So I think in some of the work we do, especially as lawyers, and as a lawyer myself, I think this is very true. I think we immediately get caught up in sort of the legal side, immediately trying to find how do we seek accountability, what sort of case can we file, how can we support sort of this search for accountability. And we sometimes forget about the human side of this work, and the sort of reason why a lot of us get into this work of wanting to help people first. So before setting out to do the work that we're actually trained to do, part of our job really is making sure that people get the support they need. So whether that's medical support, psychological support, or other types of social support, it's very important for us that that's actually the first step we take, and making sure those systems of support are in place, especially for survivors of conflict-related sexual violence, before we even think about sort of the accountability in the legal side. And I think this is also especially important because for these cases, as I think many of you know, they take a really long time. So it's important that these sort of systems are in place long term. So that was just sort of at the outset, I wanted to make sure that is a highlight. And then to get into the legal side of it, to get into the accountability side. So what could we do for her? How can we hold not only the people who did this to her directly, the people who came to her house, raped her, took her husband, but also how can we hold sort of the military commanders, the other officials that are in the chain of command responsible for the actions of these soldiers, for these crimes that were committed under their supervision, essentially. And what we've sort of found looking at this problem is that there may be a little bit of an accountability gap. So looking at Ukraine's efforts at the moment, so it seems that prosecutors in Ukraine are very likely to go after the direct perpetrator. So in her case, right, the person who actually committed the rape or who were maybe present there. And this is because in Ukraine, it's much more likely that Ukrainian authorities will be able to, physically arrest the perpetrator because they're on Ukrainian territory. But it's also because the criminal code is focused on holding direct perpetrators accountable. And for commanders, we've had prosecutors say that they really need sort of evidence of a direct order, that the commander, ordered someone to commit these crimes, which is really hard. It's very hard to get direct evidence of direct orders for these sorts of crimes, especially. And so it's kind of Ukraine's accountability efforts will be focused, very important, will be focused sort of on the direct perpetrators or on direct orders. On the other side, for the International Criminal Court, we know that the ICC will very much focus on the highest level of officials and commanders. So very much the top of the the chain of command. That is the purpose of the ICC. It's meant to go after those who are most responsible for the crimes. And in the types of cases that the ICC has heard since its founding, that's what they've done. They've gone after the high-level commanders. So as you sort of see, right, there's an ability to go after direct perpetrators. There's an ability and a possibility to go after the highest, but there's this gap about sort of people in the middle who are in the chain of command, who are commanders of regiments and units and all the different military groups who are responsible for violations that the soldiers that they supervise may have committed. So for this middle layer, especially, here is where we think that the principle of universal jurisdiction is a possibility for seeking accountability for these people. And it's an important component that we think is one of the many ways that, for Ukraine especially, we can work on seeking accountability. So for example, there are 94 countries in the world, including 36 in Europe, where we have a strong criminal code for command responsibility in the National Criminal Code, which would allow prosecutors in those countries to pursue these sorts of cases against mid and high-level commanders, even if the crimes took place in Ukraine, took place outside of their own country. So that's just to highlight sort of how universal jurisdiction is a useful tool and how it can actually really work in the context of Ukraine to kind of but to help fill in the accountability picture. Okay, so what is universal jurisdiction in more detail? So universal jurisdiction, or UJ, has been a tool for survivors for a while, and I think it's really been pushed to the forefront of the conversation since Russia's full-scale invasion of Ukraine. The idea is that under universal jurisdiction, we often use it as shorthand, like a short version for the idea that authorities in any country can open a criminal investigation into atrocity crimes committed outside of their own country, even if they don't have any connection with those crimes. So even if the crimes occurred somewhere else, even if the perpetrator or the alleged perpetrator doesn't have any connection, is not a national of that country or resident, or the victim is not a national of that country either. So doesn't require any sort of connection between the ability to investigate the crimes and where the crimes occurred. So the original idea comes from the fact that these kinds of crimes, which includes war crimes, crimes against humanity, genocide, sometimes aggression, but also torture and forced disappearance, piracy, slavery, these sorts of crimes are so serious and so awful that they're considered an attack against the international community as a whole. They're not just one country taking care of its, what its nationals do, but it's sort of considered an attack against everyone. And so the idea to be able to prosecute these crimes anywhere is to ensure sort of that perpetrators of these crimes, who are sort of considered enemies of all mankind, they have nowhere to go to escape accountability. Really, they can't travel, they can't really live anywhere without being held accountable for these awful crimes that they committed. So that's sort of the initial concept of universal jurisdiction. And through our research, we found that a lot of countries have, we were looking specifically at sort of the war crimes, genocide, crimes against humanity, and aggression piece of this for the moment. Those are often considered sort of the core international crimes. But like I said, there have been others. There are others that fall into this category. And so we found that actually a lot of countries have kind of incorporated these crimes into their national criminal code. So 153 out of 193 UN member states, which is it's about 3/4 of the world, around 75% of the world, has criminalized at least one of these crimes into their domestic law. So the crimes, what are the crimes that are covered by UJ is one piece of this. And then the second part of this is how can the country then open the investigation to look more into details into the crime, possibly prosecute these crimes, even when they're committed beyond their borders. So there are a few different ways countries have done this. So there is a set of countries that we refer to as having absolute universal jurisdiction. So this is sort of the purest form of universal jurisdiction. As I mentioned on the previous slide, sort of it's the original concept that don't require any connection between opening an investigation and the crime itself. They see it sort of as this concept of it's a crime against the whole international community. We have the ability to investigate these. And then there's about 36 countries in the world that have the ability to do this for at least one of these 4 most serious crimes. And then there's everyone else, which is countries that have implemented universal jurisdiction in some way, but they have added conditions or limitations that sort of narrow the scope of what they can do. So it still lets them do some things, but in a more limited sense. So for example, they may have said, we can open an investigation so long as the alleged perpetrator is physically present in our country. Or if the perpetrator who may have committed these crimes is a national of our country or now lives in our country. Some countries have conditions about the victim, so that the victim who was injured in the crime or in the attack is a national of their country or now resides in their country. There's a set of countries that consider these things a national interest or a state security concern. So if sort of the fact that these crimes were committed somewhere else is sort of, I guess the holding people accountable for committing these sorts of crimes is a national interest, is in their own interest to prosecute and protect kind of the international community as a whole, conceptually, not actually. And then the final category here is international treaties. There are some treaties that specifically require those who have signed and ratified the treaty to investigate and prosecute if someone in their territory may have committed the crime. So specifically, the big ones here are the Convention Against Torture and the Treaty on Enforced Disappearances. Both of those treaties have very clear requirements and obligations on states who are signing them to actually, if they know or believe someone is on their territory who committed either of these crimes, the authorities must investigate them, even if the crimes occurred somewhere else. And so, as you see, sort of states or countries, territories implement universal jurisdiction in different ways. Some have limitations, some don't, but there's a lot of possibility about using these sorts of laws. So looking at the big picture, 148 out of 193 UN member states have some kind of law that would allow them to investigate at least one of the crimes, even if it was committed beyond their borders. So that was sort of a very brief overview of sort of the 2 main points around the crimes and jurisdiction for the universal jurisdiction principle. And we know that there are many more things. There's procedural issues. There's a lot of nuance in the law. And so this was meant to be just a highlight. And as we ourselves were researching a lot of what do the laws look like? What do our options look like? Especially last spring after the full-scale invasion, we realized we wanted to share a lot of the information that we were collecting, and we decided to turn this into a much bigger project. So that was the intention behind this big project that we launched called Justice Beyond Borders, which we launched earlier this year in February. And what Justice Beyond Borders is, as you already sort of heard, is it's a mapping tool. It covers 216 jurisdictions, so all the UN member states and some territories. And it includes I'll kind of walk through some of the key features of it, but it includes sort of the key criminal parts of the code, on the crimes, on the jurisdiction, on procedural issues or other considerations. We also map whether the country has specialized units or whether the country has heard and actually tried a universal jurisdiction case. The tool right now is meant to be sort of a foundational tool. So it covers the 4 kind of foundational crimes. So war crimes, crimes against humanity, genocide, and aggression. But we really want to expand it. We want to add pieces, like I said, of torture and forced disappearance. We want to add information on victim support, possibly conflict-related sexual violence. There's a lot of issues that feed into this. So I'm just flagging right now it has 4 crimes, but we really do want to expand it. And so I'm not going to walk through the whole thing, but I do want to show sort of the main features. I will let everyone explore the tool on their own time. But about the project and methodology will give you more information about sort of why we launched this, how we launched it, how we conducted our research, and our key findings. And then the main part of the tool will let you sort of search and filter countries. So, for example, if we go into the world view, the kind of search function on the left side will let you search, for example, which countries, it's the ones in green, which countries have criminalized genocide or war crimes, or, for example, which countries have criminalized all 4 crimes. So we'll let you sort of search the world for these crimes. There's a section on this about jurisdiction. So, for example, looking at which countries require, let's say for war crimes, that the alleged perpetrator is present in that country. So it lets you sort of search the different requirements that a country might have about how they've implemented universal jurisdiction. Just to show you a few more pieces, we track the sort of, as I was talking about before, commander superior responsibility, which countries have implemented this. So these are the 94 that I was talking about earlier that do have some way of holding mid and high level commanders responsible. We have some information on Rome Statute, signature, ratification, domestication of the Rome Statute. And then we have information on whether the country has heard a universal jurisdiction case and whether they have specialized units. So you can also conduct this search by regions and then clicking into countries. So for example, let's pick Germany. Clicking into Germany. Germany, I think, as you may know, right, has been sort of a leader on universal jurisdiction. They especially, excuse me, had a lot of cases around crimes committed in Syria, in Iraq. And so Germany has a very sort of comprehensive legal landscape for this. So here we've mapped out, pulled out parts of the German criminal code for each of these crimes. We have tracked how sort of the conditions required for being able to open these sorts of cases in Germany. I'm not going to go through everything. I will let you click through it. But the final sort of piece to flag here is for countries where other NGOs in the space have done sort of an in-depth study of what universal jurisdiction looks like in that country. We link to these reports here. So for example, this is the Trial International and Open Society Justice Initiative, very detailed report on universal jurisdiction law and practice in Germany. So it's meant to sort of collect all this useful information. France as well has a lot of reports written about it. So that I'll leave you to explore the full site. I just wanted to give a little bit of a crash course of the main features. And just to highlight again, if anyone is very interested in giving any feedback or has any comments about the tool, we're always open to those. And like I said, we're really looking to expand it as well. And I think with that, I'll pass it over to Katja.
Thank you very much, Antonia, and thank you very much, dear colleagues, for inviting us. Вітаю всіх. I will
Greetings to everybody.
our presentation by going in a slightly deeper detail about the dynamics of UJ proceedings internationally and how Russia's full-scale invasion has impacted that dynamics. We will look into the most recent cases adjudicating atrocity crimes and especially CRSV conflict-related sexual violence. And we'll also see how Ukraine does or does not live up to the expectations to amend its domestic legislation and provide domestically, with respect to atrocity crimes, what it demands other countries to provide to it. Let's please look at the statistics. I think the numbers are quite illustrative. We see that essentially in 2022, in comparison to 2021, the amount of cases has increased almost by half. The amount of convictions in universal jurisdiction proceedings is also increasing, and the convictions concern both female and male perpetrators, although the males still are predominant. And what's also very interesting that the UJ universal jurisdiction proceedings concern all three atrocity crimes, and knowing that, for instance, the crime of genocide is one of the most difficult to prove to under international law, the domestic jurisdictions do not shy away from taking up these proceedings. And Antonia and I will further comment on the two cases concerning genocide against the Yazidi community as adjudicated in Germany. What's also important is that domestic UJ proceedings in certain ways demonstrate the tendencies that we see in international criminal justice, especially within the International Criminal Court. And here I will single out two. First, there is the growing collaboration between domestic human rights NGOs, CSOs, as we wrote here, civil society organizations, and criminal justice professionals, again, internationally and domestically. And this new phenomenon is quite obvious because it's the NGOs who are the first responders and who help both foreign investigators, prosecutors, as well as international investigators and prosecutors get the principal understanding where the key victims and witnesses are, where the key lines of evidence are. And as we know, for instance, the International Criminal Court, because of that enhanced collaboration with the civil society, has issued the special guidelines about the documentation of atrocity crimes. And this essentially is also both the development and the challenge for the domestic investigators and prosecutors leading the UJ proceedings. And the second particularity, and here we can move to the next slide, is that CRSV remains under-prosecuted both in international courts and in domestic courts in the UJ proceedings. And the number is quite illustrative, and I'm referring, by the way, to the annual review of universal jurisdiction proceedings, which is compiled by a number of the leading organizations working in the field. Antonia has mentioned a few: Redress, Trial International, European Center for Constitutional and Human Rights. And they indicate that, for instance, out of 125 charges in UJ proceedings in 2021, only 17 concern CRSV and gender-based violence. So it's interesting, I think, for us as Ukrainian specialists to reflect, because on the one hand, we are in a right way self-critical about the difficulty of prosecuting sexual violence in Russia's aggression and the need to prioritize this type of violence in a sensitized manner more. On the other hand, we also see that it's a natural development, that the lack of prioritization, the challenge of dealing with these particularly vulnerable victims and witnesses is there for other domestic jurisdictions as well. We will see in further cases that CRSV charges are often brought later during the UJ proceedings. They're oftentimes combined with other charges such as torture, which is again quite reflective of what we have seen in Ukraine's domestic proceedings regarding sexual violence in war. And also, quite interestingly, oftentimes in an understandable or cautious manner, foreign domestic investigators and prosecutors would first charge sexual violence as individual acts, and then as the new evidence emerges and as the case progresses, they would enhance the charges to qualify sexual violence, for instance, as a crime against humanity and not as an individual act. And we can skip to the further slides, please. And the next one, please. And we can start discussing the cases. And here I give the floor again to Antonia. Thank you.
Thanks, Katya. So just briefly, we've pulled out a few example cases specifically related around CRSV and UJ to highlight some of the things, especially that Katya just mentioned on the challenges and some of the opportunities. So this first one is the case of Lumbala in France. So we wanted to highlight this one because it's actually, so it's an ongoing case. It has not yet gone to trial. We believe it's going to trial next year. And it's actually a case that the Docket is involved in as a civil party before the courts in Paris. So to give a brief background, so Roger Lumbala, he's a Congolese citizen. He was a former head of an armed group that in 2002 and 2003 was sort of involved in committing atrocities in the DRC as part of the Second Congo War, Civil War. And so there were various UN reports and human rights reports that documented some of these violations. They included sort of torturing, killing, raping civilians, as well as a list of other things. And so a few years after these events, Lumbala was living in Paris. And so French authorities actually opened an investigation into him and arrested him in 2020 while he was living there. So it's a case of the crimes occurring in the DRC, but France, under their criminal code, has the ability to open the investigation and to proceed with the prosecution, because he was a habitual resident in France, even after the crimes were committed. So he is charged currently with the crime against humanity of slavery, torture, and summary executions. And then we have been involved in this case, along with local partners and other international NGOs as well, specifically to bring CRSV victims into this case. So our work over the past year and a half has been to identify groups of victims who were not at all previously part of the proceedings. Conflict-related sexual violence was not part of the initial sort of charges from the prosecutor. And so we've been working with our partners on identifying victims, bringing those victims to Paris to testify in front of the judge so that their testimonies are now part of the case. And as Katya just mentioned, sort of characterizing these violations. So it is very likely, just sort of looking at the French criminal code, that their violation and the groups of victims we represent were all raped by soldiers. So we have a group of two groups of victims in that category. And it's very likely their sort of violations will be characterized as a crime against humanity of torture. Simply because in France, in 2002 and 2003, when these crimes occurred, France, in its national criminal code, did not have the crime against humanity of rape at the time. That reform came later. And so because of the way the code is written, these will likely come in under torture. But we still think it's an important case to be part of and make sure that the testimonies are included, because previously they were not included. And so that has been sort of our advocacy around this, making sure that these stories and accounts are part of the narrative of the crimes that he might be complicit in. And then, of course, sort of supporting the victims as part of these proceedings through sort of psychological and social support. The second one we wanted to highlight, and I'll start and I'll hand it back to you, Katja, on this case, is one of the Germany cases. It's the Koblenz case involving the Al-Khatib detention facility in Damascus in Syria. So it is a case we wanted to highlight both because of sort of the nature of the crimes and how sexual violence was charged, which I will let Katja talk about. But also because this case involved higher ranking government officials. So both a little bit up the chain of command as well as a government official, not sort of rebel leaders or armed groups outside of the government structure. So this case, there were two defendants in this case. They were both former officials of President Bashar al-Assad's security apparatus. So they worked in the detention center and were sort of part of the systematic torture of political dissidents and activists who were being imprisoned in these detention facilities. And I think with that, I'll pass it to Katja to sort of talk about the nature of the crimes, but we just wanted to highlight sort of the higher ranking officials in this case.
Thank you very much, Antonia. And this is quite an emblematic case because it was the first major conviction in Germany for essentially state-sanctioned torture, which included sexual violence in the form of rape and other forms of sexual mutilation. And what's importantly also is that this case concerned men, the victimization of men in the official Syrian state detention. And as we know, for instance, from the former special advisor of the prosecutor of the ICC on sexual and gender-based crimes, from Patricia Sellers, who developed the investigative strategies on sexual violence for the Yugoslav and Rwandan tribunal, that the male victimization still remains largely unaddressed. And if we look the way sexual violence is reported in the Ukrainian context, both domestically in Ukraine, but also in international media, and the way that impacts potential case selection and prioritization, we see that male victimization is not highlighted enough. And this case is, of course, a good guidance. And also importantly, this case also overcautiously and perhaps strategically rightly first look at individual acts of rape and torture, but then brought the crime against humanity charges alleging the widespread and systematic nature of the weaponization of such torture, sexualized torture, by the Syrian regime. The next case, and if you could move to the next slide, please, is one of the Yazidi cases. The Yazidis are a religious minority that resides in Iraq and in Syria, and they have been particularly targeted by ISIS, by the Islamic State, with a wish to convert them and essentially to eliminate also their religious, ethnic, and cultural identity. And the Yazidis have become, well, sadly, famous for a number of reasons. First, their famous survivor, Nadia Murad, became the Nobel Peace Prize laureate for actually bringing the issue of conflict-related sexual violence on the international policy and legal agendas and really advancing holistic support to survivors, which will be an important point of discussion further today when we speak about Ukraine. And second, it was the trials concerning the Yazidis under the principle of universal jurisdiction that also brought up the genocide charges. And Antonia and I are highlighting two of such trials. First, and you can see the slide now, concerned a German national and her husband who essentially enslaved the Yazidi woman and her child, which resulted in the child's death. This was the first conviction concerning genocide against the Yazidis rendered by a German court. The final conviction, which is not appealable. And the thing is that although it's also very interesting, although during in the media coverages of the violence against the Yazidis, we hear a lot about sexual violence. in this particular case, the charges did concern enslavement and killing, but sexual violence was still mentioned in the descriptive part of the judgment. So it's very interesting that on the one hand, it's a very groundbreaking and important judgment by a German court, yet on the other hand, we are seeing that I think, which we as the lawyers and general public could expect the court and the prosecution initially and the court to comment on, the widespread weaponization of sexual violence was not addressed in much detail in this case. And here we go to the next slide, which is a slight change. It concerns a female accused, yet another German national, who was charged with aiding and abetting a number of war crimes and crimes against humanity, including rape and torture. And this case, which is currently still awaiting the final judgment in the appeal, yet still at the initial instance, the defendant, Ms. Nadine, was convicted for aiding and abetting expressly by using torture and rape. And this is yet another groundbreaking step in not just making domestic pronouncement on genocidal politics concerning the Yazidis, but also expressly specifying the use of CRSV in these cases. And in the next slide, we finally move to Ukraine, and we will analyze how the UJ dynamics has changed in and around Ukraine before and after the full-scale invasion. Now, it's interesting to note that the annual review on UJ, to which I referred to previously in this presentation, has mentioned that since 2017 at least, Germany has had a Ukraine investigation. But apart from this fact of the country having an investigation, we don't find any more details on such investigations, let alone orders, arrest warrants from Germany or any other country in these annual UJ reviews before the full-scale invasion. So we can say that this route, the UJ avenue, was quite dormant and not activated neither by either by foreign countries or actually by Ukraine itself. It's quite apparent, and the many Ukrainian lawyers attending this webinar would know how proactive both the Ukrainian prosecution and the civil society have been since 2014 in catalyzing, for instance, the ICC investigation. Yet at the same time, there hasn't been enough proactivity with respect to UJ as an alternative and parallel and mutually catalyzing a route of accountability. I will post a link in the chat, and then the colleagues from Eurofem will hopefully repost it on Facebook. There was the initiative from the prosecutor's office for Crimea to enhance this discussion of the possible UJ proceedings into Ukraine, and there was also a separate discussion with certain lawyers from Gidnica 37 chambers, from the mentioned European Center for Constitutional and Human Rights Law, but those discussions were rather about the encouragement of such proceedings than about the specific steps already taken. Here we move to the second slide. Much, of course, has changed with the full-scale invasion. Before that, and this is just a brief overview of the key international and domestic Ukrainian instruments discussing the approach to holistic justice, not just to accountability, but to transitional justice and reparations by Ukraine. And if we look attentively at these documents, they also do not mention UJ, which is yet another indication that, unfortunately, again, as the state and as the civil society, Ukraine has not prioritized UJ before the full-scale invasion. And here we move to the next slide, which speaks actually quite apparently about the massive change that has happened since 2022. We see already a big amount of even political encouraging resolutions from the Parliamentary Assembly of the Council of Europe, from the EU Parliament, supporting the domestic UJ investigations into alleged atrocity crimes perpetrated amid Russia's aggression in general, and with respect to conflict-related violence in particular. And it's very interesting that at least one of those resolutions, and Antonia and I went through them yesterday while preparing, for the presentation saw that there's this patchy reference that the UJ is generally supported with respect to sexual violence, but sometimes there is a specific emphasis on sexual violence against women. And we regard that emphasizing women as particular victims of sexual violence is important in saying that there are different categories of victims, and of course they need specialized, sensitized support, but such mentioning again could also be detrimental to realizing the amount, the scale, the gravity, and the particular different gendered nature of sexual violence addressed against men. So we are hoping that both domestically Ukraine and foreign jurisdictions, that they look at this atrocity crime holistically, of course understanding the needs of women, but also prioritizing other victims such as men, children, non-binary people, and the elderly people. The next slide, please. Philip Bryant, who's the head of Trial International, one of the leading organizations working on UJ, has actually supported, and I'm providing just one of the articles, is the statement that I think rings true not just for universal jurisdiction, but for international criminal justice as such, is that Ukraine has become this watershed moment, and it's important to use this momentum for justice to really expand it not just to Ukrainian survivors, but to survivors of atrocity victims globally. And strategically, it could also be the right approach of Ukraine to say, to communicate it to the other countries, to other jurisdictions. So now that you take up more cases related to Russia's aggression, you also train more your domestic investigators, prosecutors, and judges in dealing with these cases and expanding them to more Syrian Yazidi cases, to the cases concerning Ethiopia and Yemen. And we move to the next slide about whether TJ is just about the expectations of Ukraine, or is it also about the steps which Ukraine has to make as a state? And there is an interesting parallel in how Ukraine approached universal jurisdiction and the ICC, because in both cases Ukraine demands investigations, and here I mean Ukraine as the state and also Ukrainian human rights NGOs. But on the other hand, we see the lack of action on the obligations that Ukraine should do itself. For instance, with respect to the ICC, of course, this is the issue of the ratification of the Rome Statute, to see the sort of this reciprocity in expanding the court's jurisdiction and supporting it as much as possible, including through the symbolic ratification. And the parallel, quite similar tendency is with UJ. So while the demand to support foreign proceedings concerning atrocity crimes in Ukraine is valid, Ukraine should also finalize the overdue reform of its criminal and criminal procedure legislation to allow potentially UJ proceedings in Ukraine concerning atrocity crimes perpetrated elsewhere. Now, the practicality of such UJ trials in Ukraine at the moment, of course, could be discussed. And of course, there is a valid argument that Ukraine now has almost 100,000 conflict-related cases, and it will not be able to prioritize atrocity crimes perpetrated elsewhere in its criminal justice system. And yet the symbolic act of showing that our criminal and criminal procedure code are as well equipped as the other codes of other nations to act upon atrocity crimes when Ukraine has the capability to do so, when it has processed at least a little bit its own conflict-related proceedings, is an important step. And here I will briefly mention the draft law, which the majority of you probably know, this draft law 2689, which was aimed to do exactly what I have just discussed, because it was aiming to incorporate the whole catalog of war crimes into the criminal code. It was introducing the notion of crimes against humanity into the criminal code. It was stating unambiguously that atrocity crimes and certain other crimes, such as torture, that they do not have the statute of limitations and can be prosecuted 10, 20, or 100 years after the perpetration. This draft law also actually introduced absolute universal jurisdiction into Ukraine's legislation, with a small caveat that this provision will be enacted once Ukraine has implemented other amendments into its legislation. So we can say that this provision was really symbolic but crucially important. And yet, unfortunately, as we know, the parliament has passed this law and the president has not signed it yet. So it is a great hope that when an alternative draft law appears, that it addresses not only the proper domestic criminalization of war crimes and crimes against humanity, but that it also does this important symbolic incorporation of UJ in Ukraine's legislation, opening the doors to Ukraine having such proceedings, helping atrocity victims worldwide when it's ready, when it has processed some of its conflict-related cases related to Russia's aggression. And here we also was a request from our colleagues at URFAM, but it is also what Antonia and I wanted to finish with. We wanted to finish with some positive assertion with the light and with the connection of UJ and reparations. Because Ukraine is quite unparalleled, and URFAM are an important agent of change here, how it is building the program of reparations for atrocity survivors in general and for survivors of sexual violence now amid the ongoing armed conflict. And the question is, of course, how these policies in Ukraine might correlate with potential reparations abroad or the UJ proceedings abroad. And while we're still doing our research on this issue, we have arrived at a conclusion that the way lawyers and investigators and prosecutors and other professionals such as psychologists, language specialists, assist Ukrainian victims in going through the universal jurisdiction proceedings, how they provide the mental health support, the couple counseling to these victims who are ready to stand the long trials somewhere abroad, that this already is a small, urgent form of urgent interim reparations as we know it. But of course, it's still up to Ukraine to decide the specific modalities of its reparations policy and possibly to discuss with at least the core partners within the European Union who currently seem to be at least most proactive with respect to UJ cases and Ukraine as to how those proceedings might impact the right of victims of atrocity crimes and sexual violence to remedy and redress. And this, we would like to conclude with this final slide. You see Nadia Murad, the mentioned Yazidi survivor, who is the great agent of change for justice, wider justice, not just accountability, but reparations for survivors of conflict-related sexual violence across the globe. And this is her visit in Kiev just a couple of weeks ago, being in the company of our amazing survivors, of members of SEMA Network Ukraine. These are the women who have been through conflict-related sexual violence and are very public, not just about their experience, but about them being willing to contribute to the elaboration and the implementation of all reparations and justice policies benefiting them as survivors. And also the picture includes our colleagues from URFAM and the key Ukrainian policymakers who are now working on elaborating urgent interim and wider reparation policy for Ukraine. So we were hoping that both these policies and more sensitized, informed UJ proceedings concerning the atrocities perpetrated in Ukraine will happen, and that also Ukraine will live up to the expectation and ensure that its legislation is also open to helping victims of atrocity crimes elsewhere, and that it will amend its criminal code to incorporate UJ properly. Thank you very much for your attention, and I think we can take the questions.
Дуже вдячна, насправді, за...
Thanks a lot indeed for this. So on the one hand, this was a straightforward description, but this topic is really complicated for me, as well as the topic of universal jurisdiction. But I was able to sort this topic out a bit. I have a question, and I will use my right as a moderator to ask it.
Ви частково його торкнулися, але я б хотіла спитатись більш предметно, що
You have responded partially, but I would like to ask specifically, what can Ukraine and civil society organizations in Ukraine, what they can do to use this tool of universal jurisdiction abroad to bring the perpetrators to responsibility of the middle or higher rank? As we have mentioned already, how can we do advocacy on our side? Should we talk more with our government so that Ukrainian government should communicate with other countries' governments? Or can we cooperate with international organizations as well in order to work in this regard in a more efficient way?
Should I start, or do you want to start, Katya? Okay, I'll start and then please chime in, Katya. But I think my initial thought would actually be both of the ways you mentioned, both through sort of, I think the key here is sort of the collaboration piece, right? Because especially, so if we're talking about the situation in Ukraine, civil society there is going to have sort of the best view into what is happening, what has happened both with the crimes, what is happening with survivors and victims, what are their wishes regarding, accountability or justice? Does it include accountability possibly abroad? So I think Ukrainian civil society is such a powerful force in this and knowing what survivors want and need. And so it is sort of on one side, sort of spreading the message about the ability for this accountability avenue abroad. And then it is about collaboration also. So if, as Katya mentioned, Germany has this investigation open into crimes in Ukraine. As I think sort of there are many countries, especially in Europe, that opened investigations that are collecting information through some of the joint investigation teams. They're working with the ICC. There's been so much political will in establishing essentially all these channels of communication and working together and collaborating to get the information to the right authorities who might be prosecuting crimes. So it is also about sort of, to the extent that it's possible for Ukrainian authorities to be open to sharing some of the information they might have with colleagues abroad, prosecutors abroad, who have cases open, who might be willing to help, right? Not take the case from anyone. I think we all believe Ukrainian authorities should be the one prosecuting to the extent possible, but there are gaps, right? Like we pointed out, like for mid and high level commanders, or just the ability to handle so many cases. I don't know what the current and most updated number is for open war crimes cases in Ukraine, but it's tens of thousands, right? So there has to be some will on Ukrainian side, and we've seen it. So I think it's there to collaborate and work with colleagues abroad in these investigations. And then the last part you said about sort of international organizations doing this work. I think we've mentioned a few during this presentation. There are a lot of experts working in this field trying to figure out how these cases can be brought. We're one of many. And so there is sort of the ability also for survivors or victims in Ukraine who really want to pursue this to be connected with international organizations. So it's a little bit of a multi-pronged approach, but that would be sort of my initial thoughts. Katya, I don't know if you have anything to add.
Yes, thank you. I fully support that it's a multi-stakeholder approach. And I think actually human rights NGOs in Ukraine, they know which domestic human rights NGOs already work a little bit on UJ. And also with respect to international NGOs, I mean, if we look at this annual review that I mentioned, it has the list of contributors on its cover, and it's easy to contact all of them. And as far as I'm aware, most of them already also work on Ukraine. So I think it's just, a question of a couple of emails. And with respect to the state approach, I think it's also two-pronged. First, it's of course, as Antonia has mentioned, it's the readiness of the Office of the Prosecutor General to share the evidence. And I mean, there are all procedural grounds for it through JIT or through direct cooperation with the domestic prosecutors' offices in other countries. But also, I think politically, it's very important to support the resolutions like Antonia and I provided in the presentations from the European Parliament, from the Parliamentary Assembly, to incorporate this call for more UJ proceedings, again, concerning Ukraine. But here I would also add to always add the argument how that could benefit, how that could open up this justice avenues for victims of atrocity crimes in other situations, because again, we're all aware about this selectivity concerns and selectivity concerns which are often attached to the way Ukraine is treated. So that would be, I think, the way to address both. Thank you.
Дякую дуже за цю відповідь. І я бачу, що
Thanks a lot for this response. And I can see that we have used 1 hour sharp. It's 5 o'clock. So far, we don't have questions in the chat, but if you have, you can send your questions to us later, and we will try to sort them out. Thanks a lot to Antonia and Katya for joining us, that you have been able to provide this comprehensive explanation about this issue and the prospects for Ukraine and what Ukraine needs to do in order to nationally use the UJ tool, which is very valuable. Thanks a lot for highlighting the information about bringing perpetrators to responsibility for committing the CRSV crimes in this war, in the Russia's aggression. Thanks a lot to our viewers who have joined this broadcast. Stay with your fam. We have a lot of events, we have a lot of trainings going on. Follow our advertisements and announcements. So this was a training dedicated to the universal jurisdiction, thanks to the JURFEM and Clooney Foundation for Justice. Thanks to everybody for this live air, and see you next time. Thanks a lot to you, and stay safe.